Please be seated. All right, our second case for today is case number 23-1006, Stewart versus Madison County School Board. Appellant's counsel.
Good morning, Your Honors, Mr. Sanders, and may it please the Court. My name is Tom Skolko, and I represent Cindy Stewart in her appeal of the order of the Judge of Compensation Claims that we contend erroneously barred her entire case based on the running of the statute of limitations. With me at counsel table is my co-appellate counsel, Shannon Macklin, and I would like to reserve 4 minutes for rebuttal.
Very good, thank you.
In Rice versus Reedy Creek, this court held that where a claimant has a pending petition for benefits at all times between the filing of the first petition and the hearing on the last petition will not be barred by the statute of limitations. Here, because Ms. Stewart had a pending petition for benefits at all times since her first petition was filed in April 26 of 2020, Rice controls and the statute of limitations did not run, and the JCC's order was erroneous.
So distinguish these cases, sort of the Rice and Black line, it seems, versus the Moyes case. And I guess what distinguishes those lines of cases, and why does your case apply? Why does Black and Rice apply to yours?
Well, Moyes, from the very first sentence in the opinion to the last full paragraph, makes clear it's addressing an entirely different issue than is present here, which is the interplay between Section 440.25(4)I, which permits motions to dismiss for lack of prosecution, and Section 440.19(3), the statute of limitations provision. Because this case and Rice do not involve a motion to dismiss for lack of prosecution, Moyes is easily distinguishable, and Rice controls. Does that answer?
I'll ask my next question unless the Chief has any follow-ups on that one. I want to kind of put our cases aside for a minute, and I want to try to peel back the layers of the provision that an entitlement to an attorney's fee in a petition for benefits can somehow toll the statute of limitations. And so separate and apart from what our cases has said on that, what is the statutory basis for allowing purely the issue of entitlement to fees to independently toll the statute of limitations?
There's several reasons for that. First, in Crittenden versus Stone, the Florida Supreme Court held that entitlement to an employer-paid fee is a benefit to the claimant given the self-executing nature of the Workers' Comp Act, and normally a claimant would have to pay their own fee. But in those limited circumstances where a claimant can have the employer pay their fee, that is a benefit to the claimant. That was reiterated by the Supreme Court in Castellanos versus Next Door Company, where the Supreme Court held that employer-paid fees are not merely an expression of legislative policy. They are constitutionally required by the Due Process Clause of the Florida of the United States Constitution.
Right, and then I appreciate those cases that say that, but I'm more focused on the tolling effect for statute of limitations and the general law, the statutory law that says that an entitlement to attorney's fees can independently toll the statute of limitations.
That's established by the plain language of Section 440.19 sub 3, which provides that a petition for benefits that meets the specificity requirements in Section 440.192, which is subsection 2 of that statute, tolls the limitations period. And if you look at Section 440.192, which deals with specificity requirements, subsection J provides that any disputed issue provides for any other disputed issue to be determined by the JCC is compliant with Section 440.192. So therefore, putting those two statutes together, any petition that satisfies the specificity requirements of 440.192 tolls the limitations period, and any petition that contains a disputed issue, such as attorney's fees, is compliant with that statute. And therefore, this court's decisions in Black, in Longley, Hospitals East, Rice, all those cases are not just consistent with the statute, they're required by the statute.
So comp is statutory. You know, it's pure statutory creation. And I'm trying to get my head around whether the legislature would intentionally create a statute that provided that their statute of limitations could be tolled for years just because there is a so-called pending entitlement. I don't see what the entitlement was to attorney's fees that was not brought to fruition.
Well, certainly, first, as I've discussed, the plain language of the two statutes considered together clearly contemplates that a claim for attorney's fees fits within Section 441.92 and therefore would toll the limitations period. But I guess the more substantive answer to that is the bifurcated nature of fee determinations under Chapter 440 requires it. A claimant, when they have a disagreement with an employer carrier as to whether or not there's fee entitlement, the only thing they can do is reserve jurisdiction on that fee entitlement because the process requires them to file a verified motion for attorney's fees, to put together evidence, to maybe get witnesses.
And at some point in time, the JCC issued an order to file the verified petition for attorney's fees within 90 days, and that never happened.
That's true. The claimant didn't comply, and the JCC ultimately dismissed the fee claim.
So is that a problem for purposes of 440.19's 3 specificity requirement? Because it says that the petition for benefits doesn't toll the limitations period unless the petition meets specificity requirements. So to the extent that the party and the JCC is calling for a verified petition, is that the specificity requirement, and is that a wrinkle in this case that's a problem?
It's not a wrinkle, it's a problem, and for several reasons. Moyes, the case that the JCC relied on, involved the specific application of a motion to dismiss for lack of prosecution.
And you think the holding in Moyes is just limited to dismissals for lack of prosecution, not voluntary dismissals?
Absolutely, for several reasons. The reasoning in Moyes that the court applied took from the Pasek and Tilley case from 1972, the Florida Supreme Court's decision, also involving a motion to dismiss for lack of prosecution. In the 51 years since Pasek and Tilley was decided, not a single case, appellate decision that I can find, has ever applied a retroactive dismissal outside the context of a motion to dismiss for lack of prosecution. And the reason for that is because, as this court explained in the last full paragraph
So
of
would there
Moyes,
be a difference in a voluntary dismissal that was the result of the EC providing some benefit, you know, an agreed upon dismissal because treatment was provided? Or in this case where there was no additional treatment provided, there was no any kind of benefits provided, it was just dismissed when nothing came to the claimant as a result?
Well, I want to address that a little bit. The record in this case wouldn't necessarily answer the question as to whether there was fee entitlement, because the record is limited to the evidence before the judge in the substantive dispute. As I indicated before, fee entitlement is a separate proceeding where the claimant would file a verified motion for fees, would present evidence which may be different than the evidence in this record. So there's no way to tell from this record whether there's fee entitlement, nor should there be, because it's a separate proceeding.
So, counsel, it seems like your argument for why Moisey is not applicable here has to do with the fact that we don't have a motion to dismiss for lack of jurisdiction or prosecution before us. But isn't a motion to compel a verified fee motion kind of similar in kind to a motion for lack of prosecution, whereas here all we have is this outstanding motion request for fee entitlement?
Absolutely not. A motion, there's two or three important distinctions between the two motions. A motion to compel the filing of motion for dismiss for lack of prosecution provides a claimant something to do to avoid dismissal, have record activity in the year before, and a time frame in which to do it. The rule provides neither. That's why when this court, in the last full paragraph of Moyes, explained that dismissal was a contingency within the claimant's control under the lack of prosecution statute, they weren't referring to actions a claimant could take after the EC filed their motion. Nothing a claimant can do after the EC files their motion can ever avoid retroactive dismissal under the logic of Moyes. They were referring to actions the claimant could have taken before the EC filed their motion. The rule provides nothing for a claimant to do before an EC files a motion to avoid dismissal, and no time frame to do it. For example, in this case, the EC could have filed their motion 2 minutes, not 2 years, but 2 minutes after the claimant reserved jurisdiction on fee entitlement. What could the claimant have done to avoid dismissal?
But on the other hand, I mean, just kind of give me on the grounds, obviously with limited to the record, why do we have these attorney fee issues outstanding after years of no activity in the case? I mean, why isn't the claimant moving to resolve the fee claim?
Well, they can if they want to, and now there's multiple methods in the statutory scheme to allow an employer carrier to get that issue heard. There's always been a motion to dismiss for lack of prosecution if the claimant doesn't do anything within the year previous. And now there's a rule of procedure that allows an EC to ask that issue be adjudicated. But unlike dismissal for lack of prosecution, that rule contains no penalty provision, doesn't tell a claimant when they have to do it, and therefore it could never be applied to support retroactive dismissal. Because as this court explained in Moyes, retroactive dismissal is a contingency, must be a contingency within the claimant's control and something they can generally avoid. They can do neither in this circumstance. And that really gets to the real heart of
Could
the
the
argument.
claimant just not file the verified fee motion?
I'm sorry, say,
What about filing the verified fee motion and
That
doing
wouldn't-
it within the 90-day window that was the JCC ordered here?
that wouldn't have avoided retroactive dismissal. If the claimant had filed the fee motion, presented evidence, gone to a hearing and lost, under the JCC's logic, that petition would have been retroactively dismissed and denied tolling effect.
And why is that again? Because it would have been granted or denied, not necessarily
Because
dismissed.
the JCC's interpretation of this statute is that dismissal by any means results in retroactive dismissal.
Well, there's a difference between denying a fee motion and dismissing a fee motion. You dismiss a fee motion either voluntarily for lack of prosecution or because there's not jurisdiction. Otherwise, you would deny it.
Well, if you deny it, it's then dismissed. I think every petition, every unsuccessful petition, by definition, will ultimately be dismissed. And therefore, to the JCC's rule simply only gives tolling effect to successful petitions, which is directly contrary to the Section 44019 sub 3. And I see
Counsel,
that
you're
I've
in
cut.
your rebuttal time, so you can choose to continue or.
Yes, why don't I pause it now, and thank you very much.
May it please the court. Todd Sanders on behalf of the appellees, Madison County School Board and Florida School Board Insurance Trust. Good to be back. I want to address some of your questions, Your Honor. I know that the Moyes issue, for lack of a better phrase, has been extensively briefed. There are 3 pending cases on that same issue. By my count, I think there's 12 briefs in this court right now on that. So just to add a few points, it's questionable in my mind whether Longley even applies here, because in Longley, Black, and in Moyes, the parties had resolved the substantive issues, the benefits that were being requested, and then agreed to go ahead and reserve jurisdiction on entitlement to attorney's fees. Here, as Judge Roberts pointed out, no benefits were ever provided as a result of a petition for benefits. Every benefit that the carrier provided in this case was provided before the very first petition was ever filed. The only possible exception to that is it was in June of 2020 when the carrier paid for a physical therapy session that took place in October of 2019. The first petition was filed in April of 2020. So it's really questionable as to whether there was ever a ripe fee claim, ever pending at all in this case, until the 2022 untimely petitions for benefits were filed. And how can you reserve jurisdiction on a claim that doesn't exist. There's no ripe claim. JCCs only have jurisdiction over ripe claims. We did not have one here. So that's how I would address some of the questions that you asked, Mr. Skoka.
Do we have enough in the record to make that determination? Or would that require additional factual basis?
I'm sorry?
Do we have enough in the record to make that determination, or would that require an additional factual basis?
Yes, sir. There's the pay ledger at page 176 of the record shows all the benefits that were provided. And every one of those dates precedes April of 20.
Okay. So all the benefits that the employer carrier provided the claimant were pre both of these PFBs?
That is correct.
Okay.
And the JCC so found. The JCC found that the last medical benefit ever provided was in November of I believe it was 2020. But nothing was ever provided as a result of a petition for benefits. Those petitions were dismissed. And in fact, the claimant, when the carrier filed the motion for verified fee petition, the claimant voluntarily went ahead and just said, okay, go ahead and dismiss my fee claims. The only reason he would do that is because you knew there was no entitlement to the fees. Because
So
no
if we
benefit
agree
had been
with you,
provided.
how do we distinguish Rice?
And I believe it was in response to the motion to dismiss, based on a failure to file the verified fee petition. And the only request that they made was that the dismissal be effective November 1, as opposed to retroactive. And then we get into the whole, does Moyes apply to a verified fee petition motion, and then a failure to follow up on it. And as I argued extensively in my brief, that there's really they're functionally equivalent in their goal. The Moyes opinion in a footnote specifically points out that another way that we can get rid of one of those dangling fee issues that just sit there for years is to compel the claimant to file a motion for verified fees, file a verified fee petition, and prove up whether A, there's entitlement, and B, how much they're owed. And that never happened here, but that's just another way. Otherwise, we would have a potentially endless statute of limitations unless someone moves forward in some manner to get rid of the lingering fee issue.
Well, you had expressed some concern in your brief about that potential, right? The concern that you'll have this never-ending, open-ended claim that's tied up only because of attorney's fees. But the carrier has a remedy for that. The carrier can move to fight a verified fee petition to bring this to closure, right? So, I mean, is that concern a real concern in light of the tools available to the carrier to bring this to closure?
Here, the carrier had two options. They could do what they did, move to compel a verified fee petition, and arguably they could have done what was done in Moyes and moved to file a motion to dismiss the failure to prosecute the dangling fee issue. They have both options here, and both have the same goal, arguably. And the fact that there may not be some of those provisions available under the rule that are available for avoiding failure to prosecute doesn't really matter. There's no entitlement to an endless statute of limitations.
But I think, and I think this was Judge Ray's question, is that the employer carrier has the ability to make sure that these things aren't dangling for years. They can file for a verified fee petition right away and bring this thing to fruition. So the concern that claimants are able to use this to toll statutes of limitations forever, there's a way for the employer carrier to make sure that doesn't happen. So doesn't that obviate that concern?
It does, and that goes to my point, though, that they're functionally equivalent, and therefore the Moyes rationale of retroactive dismissal and getting rid of the tolling effect of the petitions with the dangling fee issue should apply in this case as well. And the claimant relies heavily on subsection 3 of the statute of limitations. So all I have to do is file a facially sufficient petition, and I can toll the statute of limitations. But as this court said in McBride, That simply says that, yeah, you can toll it, but it does not address the tolling effect of an earlier filed and then subsequently dismissed petition. So yes, you can file a petition and you can toll the statute of limitations, but then if you dismiss the petition except for the fees, that statute doesn't talk about that, and that's part of what we're here about today. Can you have a fee issue holding up the statute of limitations if there is no fee entitlement? That's what we're arguing. There's no valid
Well,
right
is it,
claim.
so does your response then hinge on the determination of entitlement? So, I mean, I guess let me take you back to the question that I asked opposing counsel. Do you agree that the statute allows a tolling effect when the issue is solely entitlement to attorney's fees and the petition has, on the substantive portion, has otherwise been dismissed or resolved? Do you believe that the statute provides that entitlement to fees can continue tolling the statute of limitations?
I see nothing in the statute of limitations provisions that say that. It just says a petition. And what is it? A petition asking for generally? Benefits for the worker. The system doesn't exist for fees.
And so I believe what I heard to the response to my question is attorney's fees are a benefit. It is it might not be medical benefit, but it is a benefit that is constitutionally authorized to the claimant. And so help respond to that aspect of the argument.
It is a benefit if there's entitlement. If the lawyer has obtained a benefit for that claimant, rather than the claimant having to pay their own attorney for obtaining that benefit, it provides for the carrier to be able to pay for that to pay that fee, and that's what the Supreme Court has said is the benefit that accrues to a claimant. But if you don't have any benefits obtained, then there's no fee attachment, and if there's no fee attachment, then how can we reserve jurisdiction on something that doesn't exist?
But they did. And this happens commonly in cases. They
Right.
reserve jurisdictions for fees and something where I don't even see where fees occur. So in workers' comp cases, a petition for benefits is filed. And that's what gives the JCC jurisdiction to over the case, right?
Yes.
Without a PFB, there's no jurisdiction of the JCC. So when they dismiss the PFB, how does the JCC have jurisdiction to reserve jurisdiction on attorney's fees? And if they have reserved jurisdiction on attorney's fees, is the PFB actually dismissed? Because they need a PFB to have any jurisdiction at all, right?
That's a good question, Your Honor. I would say no. I mean, you dismiss your petition, you dismiss your petition. Now, parties can stipulate, and judges can, if you have an actual pending issue, and reserve
Well,
jurisdiction.
I don't see how
but-
parties can stipulate to the jurisdiction of the JCC without the statutory prerequisite for the jurisdiction existing.
I would agree. How can you reserve something if the petition's been dismissed?
Well, if they reserve something, the entire petition has not been dismissed, just the substantive part of it, I guess.
That is the argument that the claimant makes. Yeah.
Well, and some benefit may have been obtained as a result of filing the PFB, and then it's dismissed. The benefit was obtained sort of outside a decision, and attorney's fees are owing.
Now, I don't have a whole lot of time remaining. I would like to address the second issue raised by the claimant, and that is to what, if any extent, the Ortiz opinion applies here.
Well, we've withdrawn the mandate on the Ortiz opinion, correct?
I'm sorry?
We have withdrawn the mandate on the Ortiz opinion.
That is correct, Your Honor.
So it's of no precedential moment.
I want to thank you very much for telling us that, Your Honor. I mean, for acknowledging that, Your Honor, because the JCCs don't agree. I've just seen orders saying, I know the mandate's been withdrawn, but I'm still bound by it. And I guess what we would ask for is an opinion reaffirming this court's long-standing precedent since at least 1999, that the formula we use to determine if the statute is run is, and the only counting involved is, has more than 2 years elapsed between the date the claimant knew or should have known of the accident, that their injury or condition was caused by a work accident. Because you might have a situation where a person's got a rash, and they don't know for months later that the rash was caused by some exposure at work. that would postpone the statute from starting to run. That's a postponement provision. But if you have more than 2 years have elapsed from that day to the date that the petition is filed, this court has held the statute of limitations, 2 years, has run. Then and only then do we look to see if more than 365 days have elapsed since the last time a benefit, if any, was provided. And that's been the bright line test that this court has used since at least 1999 in New Orange County v. Best. And there is an impression amongst the bar and bench that Ortiz somehow changed that, and that now we have a different mathematical equation we have to apply, and we have to count up suspension days, and if we get more than 730 of those, then the 2-year statute of limitations has elapsed. That's the way it's being applied right now below, and so we would appreciate, certainly a PCA would be fine. As Mr. Skulka told me when I first went to join the workers' comp unit, there's nothing wrong with a PCA when he was a judge.
Counsel,
So
but I
we could
believe
go for
you're,
that.
on this issue, I believe your first argument was that the issue wasn't preserved, and so we need not reach the merits. Are you changing your position there, or you still believe this was not preserved, and
I
therefore
believe
we
it
need
wasn't
not even
preserved,
reach that?
but just for safety's sake, if you disagree, I have to make the argument.
No, I would make sure you hadn't changed your position, and you thought it was
no.
preserved at this point.
No, it wasn't, that wasn't what they suggested to the JCC as a way to avoid the statute having run. They basically just said, I had a pending petition at all times, and that told it, and Moyes doesn't apply here. That was the only option they gave the JCC.
And I think you would both agree that to the extent that we reissue Ortiz and provide some clarification, it would help everybody.
That
Okay.
that would make me a hero, at least to half the bar anyway. If there's nothing else, Your Honors, I have nothing else either. Thank you very much.
I'll just briefly touch on Ortiz. Judge Padovano in Florida Appellate Practice, I believe, said that the finality of a decision matters to the parties, but it has nothing to do with the precedential effect. Well, as long as the opinion is published, it still has precedential effect and should be followed by the lower courts. But I really want to talk more about the first issue. Mr. Sanders talked about McBride as supporting his argument. He does not. McBride and Sanchez both involve the specific factual scenario of a claimant having a pending petition tolling the statute of limitations, having that petition be completely dismissed, and then filing a new petition outside the limitations period. This case and Rice are distinguishable. This case and Rice both involve a pending petition at all times in the case. So McBride and Sanchez are clearly distinguishable on their facts, and in fact, Rice distinguished McBride on exactly that ground. But I just want to get back to I guess the big question that the court seems to have about why should a reservation of fees toll the statute of limitations? Because it has to, because there's nothing else a claimant can do to save that issue, to preserve that issue, to be heard at a later time when they file a verified petition. They must reserve jurisdiction on it. And Mr. Sanders' repeated suggestion that the claim had no merit. The statutes of limitation don't ever go to the merits. They never operate depending on the merits of a petition. They operate mechanically. And if the elements are satisfied to toll the limitations period, they toll the limitations period. And here the plain language of Section 440.19.3 and Section 440.192.2J clearly provide that a claim for attorney's fees is permissible under the specificity requirements and therefore tolls the limitations period as long as it remains pending. And Moyes doesn't change that result because
And that's
Moyes
true in a
deals
case like this where the whole attorney fee issue turns out to be a phantom of sorts because it was just went away.
Well, the claimant abandoned it, but the claimants file petitions all the time for other substantive benefits. This court has never assessed the tolling effect of those petitions as to whether or not they were ultimately meritorious or not. The statute of limitations simply does not operate that way. This would be an unprecedented application of the statute of limitations to consider the merits of the underlying claim in determining its tolling effect. the
Counsel,
legislatures.
let me ask you one. The JCC, who was, again, dutifully trying to follow precedent, seemed to be focused on language in Moyes, the by any means language, and that by any means is certainly broad. And so in her effort to dutifully follow that language, how do you get around the broad application of by any means to distinguish the case?
I see my time is just about to expire. Do I have permission to answer that question?
You do.
Thank you very much. That language has already been interpreted by this court in Rice as not meaning what the JCC says it means. In the exact same retroactive dismissal argument was made based on the McBride decision, and this court in Rice said, no, we didn't mean that when a petition for benefits is always pending.
Now, Rice was before Moyes, right?
No, but Rice was after McBride, and in McBride.
But I'm sorry, but I think the JCC was looking at our most recent pronouncement, and we can get into a whole debate about, if you have opinions that conflict, but I believe the JCC was looking at the most recent pronouncement, Moyes, by any means, the language that was used.
No, but I guess I'm sorry, I didn't give a great answer, but what I was trying to say is that language was a quote from McBride. And in Rice, this court distinguished McBride on this exact fact. So clearly, that language can't mean what the JCC and the EC says it means.
Thank you,
Just
that's
if
very
the court has no
helpful.
further questions.
Thank you, Counsel.
Thank you very much, Your Honor.
All right, that concludes our cases for today. We're adjourned.
All right.